what's happening with the Ultratech Binani deal. The NCLT bench of Kolkata has ordered Binani Cement Committee of Creditors to evaluate Ultratech's revised offer. What's the latest, Neha?
Well, indeed, finally there's clarity coming in this case. Remember, the matter has been going to and fro for about 2 months now. In fact, today NCLT Kolkata bench has ordered the resolution professional to consider the revised offer submitted by Ultratech Cement. Do remember that in March, the Committee of Creditors, after a close round of bidding, had selected Dalmia Bharat to be the highest bidder. After the bids had closed, Ultratech had submitted a revised offer which was rejected by COC on grounds that the bidding window had closed. However, today the NCLT Kolkata bench has directed the Committee of Creditors to evaluate the proposal submitted by Ultratech Cement, the revised bid submitted by Ultratech Cement, and they have also allowed Dalmia Bharat to match the bid submitted by Ultratech Cement. So all in all, we can expect a fresh round of bidding between these two players. Remember, they were neck to neck in March as well when the final round of bidding was taking place, and now the round is going to be open to Dalmia Bharat should they want to improve their offer to acquire Binani Cement. The objective of the order clearly seems to be maximization of value as far as all the creditors are concerned. But as far as the IBC is concerned, many questions remain to be answered. Will this case be a benchmark for further reference as far as many such cases coming in the future are concerned? But as of now, of course, the NCLT has been very clear in its ruling, saying that maximization of value should be given consideration. And basis this, they have asked the Committee of Creditors to reconsider and accept the revised offer submitted by Ultratech Cement. What will Dalmia Bharat do? Will they move court or will they also revise their offer? This part of the story remains to unfold, but this is how this stands at this point of time.
Right, so that's the latest. That's the NCLT Kolkata giving Ultratech 3 days' time to come up with a resolution plan, which even Dalmia Bharat will get an opportunity to match. Remember, IBC is a new law, and every one of these big cases is turning out to be an acid test. We're going to get down to the basics of that and get an expert on board to not just dissect the latest development in Binani Ultratech, but also discuss the SR lenders meet, which is currently underway. Before we go do that, here's Binani advisor Sameer Kaji maintaining that what the court has decided is indeed a positive step.
I would say it is very positive from a value maximization perspective. All stakeholders will eventually benefit, and I hope the highest bidder will ultimately get the company. Dalmia may have a possibility to match the same, and then Ultratech would again be given an option to top it. All this needs to be completed, I understand, within 3 days by the COC. Purely on numericals and the discussions we have had, Ultratech would be the right candidate, and I feel we are almost there. Yeah, that's what you're right in saying that. But you know, one doesn't know till the final decision COC takes. As we start moving on and precedents are set or certain clear decisions have been made, I don't think this would be the case for resolution for, say, asset number 6, 7, 8, 9 onwards.
There you go. That's the, advising CEO to Binani on the latest development that has taken place. That's as far as that mega corporate battle between between Dalmia Bharat and Ultratech goes. Like I told you, there's already a meeting underway as we speak of SR Steel Committee of Creditors deciding the eligibility of both ArcelorMittal as well as New Metal. Early indicators being there's certainly going to be an uphill task for both of those firms. But let's take forward the story of Binani Cement with Sriram Subramanian, the founder and MD of InGovern, as well as Ashwin Parekh, the managing partner at Ashwin Parekh Advisory Services. Good afternoon, gentlemen. Thanks a lot for joining us here on ET Now. So if I could come to you first, Mr. Subramanian. So the NCLT Kolkata, what do you make of the decision? Ultratech allowed to bid, gets 3 days' time. Then Dalmia Bharat is allowed to match that. So you can perhaps call that a right of first refusal, a new version of that. Do you think this is the right way to go? And, in every case, we're seeing a different outcome from a court. So I don't even know if you can say this is going to act as a precedent for the other dirty dozen companies.
Yeah, good afternoon. I think the IBC itself is a new law, and every stakeholder, including the NCLT, is trying to figure their way around. And obviously, at one end, the conflict or the requirement is to maximize value, and at the other end, follow due process. So these are conflicting, I would say, pulling decisions in many directions. And that is where one needs to look at it case by case. In this case, of course, that's where they have just given 3 days, and they have given the other party, which is Binani Cement, a right to match the price and sort of give the decision to the COC to finally decide on. So, and I don't think this case should be taken as a precedent for all other subsequent cases. As I told you, each case has a merit of its own, and hopefully some of these, once we get resolved, and once some sort of, I would say, all the troubles or all the various scenarios are sort of laid out, I think then when the revised IBC comes out, the law itself takes into account these very many scenarios and lays proper guidelines out.
Mr. Parekh, I'm Neha joining you from the Mumbai newsroom. Good afternoon. I do know for a fact that you have been following these insolvency cases very keenly. I want to ask you, do you think it is fair for a revised bid to be considered? Do you think it's fair for a bid that is submitted late to be considered? I'm talking about following the IBC in letter and in spirit. Now, we do know that IBC is a new law. It needs to be tested. But within the framework of IBC, would you say that the current proceedings, which are causing a lot of delay as far as resolution is concerned, is going the right way?
Well, I mean, I must say that each case is becoming a unique case, and therefore what is right and what is wrong perhaps is a little difficult to judge. But I must admit that if you will go into, the detail of various cases which are now happening, we have 2 or 3 sets of cases before us, before the NCLT IBC, and they are for resolution out of the 12 and then another 12 thereafter. You see, the one thing that is becoming very clear is that wherever there is a technical matter, sort of, which is under dispute. For example, whether, let's say, there is any order of conflict in regards the bidding, I mean, that is with the original promoter. So it's a technical subject. And then there are process-related subjects. So, I mean, and I was right from the very first day, when this particular matter happened, I thought that the matter was more process-oriented rather than technical-oriented or technicality of the. So, I mean, are both the promoters who are bidding for this particular asset, are they both eligible? The answer is very clear that they are both eligible. As far as the set of objectives before NCLT IBC is concerned, the objective, one-line objective is, or one statement objective is to maximize, the recovery as much as possible. So, I mean, in that regard, sort of, if I'm now seeing some pattern evolving, too early for me to to really sort of analyze or to make something like a rule out of it. But I mean, one is getting the sense that between the technical aspect, that is whether the law is being complied at all, or whether the process, which is a part of NCLT, whether that has been complied or not. I suppose somewhere you're getting an impression that with the larger objective of maximizing the value, for the asset, I think that is prevailing. So we're now getting some sense that wherever there will be a process issue, the process issue may be looked upon, by both COCRP and then by the bench or by the NCLT. And then they can take a view in regards to the process, which may be a little open-ended. I mean, it's not setting out any precedents whatsoever. It's not establishing any kind of a rule. But the larger rule, if I were to say, is that process-related and law-related. That is, if law is very clearly saying that something is a no-no, then it's a no-no, basically. Then neither COC nor RP nor NCLT would then sort of, evaluate that. So that seems to be, I mean, the interpretation I am at least getting out of this.
Right. Right. Thank you so much, Mr. Parekh, as well as Mr. Subramanian, for taking out time for us and explaining us about what's happening latest with the NBFC space.